Chapter 12. Abduction. Section 205. Definition. Abduction is the unlawful taking by force, fraud or enticement, of a woman or girl for the purpose of prostitution or marriage. Abduction has been also defined as the taking or carrying away of the child of a parent, or the wife of a husband, either by fraud, persuasion, or open violence, as the UN lawful seizure or detention of a female for the purpose of marriage, concubinage or prostitution, as the unlawful taking or detention, by force, fraud, or persuasion, of a person, as a wife, a child, or a ward, from the possession, custody, or control of the person legally entitled thereto, as the taking and carrying away of a child, a ward, a wife, etc., either by fraud, persuasion, or open violence, and as the taking of a female without her consent, or without the consent of her parents or guardian, for the purpose of marriage or prostitution. Section 206. A statutory crime. At common law, abduction probably is not a crime, separate and distinct from that of kidnapping. In England and in this country statutes have been enacted making abduction a distinct crime. These statutes, however, are not at all uniform. Section 207. Early English Statute. As early as 1488 a statute was enacted in England making abduction a distinct crime. This statute forms the basis of most of the statutes in this country upon this subject. Section 208. Modern English Statute. Since the repeal of the Statute of Hen. 7. Other statutes have been passed in England relating to abduction. The present ones enumerates the following 5 classes of cases in any one of which a person renders himself criminally liable for abduction. 1. One who, from motives of lucre, shall take away or detain, against her will, any woman of any age, having certain property or expectancies, with intent to marry or carnally know her, or to cause her to be married or carnally known by any other person. 2. One who, with such intent, shall fraudulently allure, take away, or detain such woman, being under the age of 21 years, out of the possession and against the will of her father or mother, or of any other person having the lawful care or charge of her. 3. One who shall by force take away or detain against her will any woman of any age, with such intent. 4. One who shall unlawfully take or cause to be taken any unmarried girl under the age of 16 years, out of the possession and against the will of her father or mother, or of any person having the lawful care or charge of her. 5. One who shall unlawfully, either by force or fraud, lead or take away, or decoy or entice away or detain, any child under the age of 14 years, with intent to deprive any parent, guardian, or other person having the lawful care or charge of such child, of the possession of such child, or with intent to steal any article upon or about the person of such child, or any person who shall with such intent, and knowledge of the facts, receive or harbor any such child, provided that a person claiming to be the father of an illegitimate child shall be excepted from the operation of this section. Section 209. Statutes in this country. Statutes have been enacted in the various states of this country making abduction a distinct crime. These statutes, however, as heretofore stated, are not at all harmonious. Some of them contain substantially certain provisions of the present English statute, but, upon the whole, they vary greatly. Section 210. Abduction of wife. Civil remedy. At common law any person who entices or takes away a man's wife by fraud, persuasion or violence, renders himself liable to her husband in a civil action. The enticement must be caused by the defendant knowingly, and by direct and active interference. It is not essential, however, that the defendant's conduct be the sole cause of the wife's desertion, but it must be the controlling cause. The gist of the action in such case is the loss of the wife's society. The wife owes to the husband the duty of living with him, and seeking to promote his interests and happiness, and by preventing the performance of that duty a wrong is done him, involving a pecuniary loss as well as a loss of peace and comfort in the marriage relation. Whoever is the wrongdoer, whether the father of the wife or any other person, he should be subject to an action for damages by the husband. The husband's remedy in such case is by writ of ravishment, or by an action of trespass viat armis, the ux or raptu et abducta. Harboring another's wife is also actionable. The ancient common law was so strict on this point that if one's wife missed her way upon the road it was not lawful for another to take her into his house unless she was benighted or in danger of being lost or drowned. But under modern law the severity of the old rule is much lessened. Section 211. Consent of girl immaterial. Under statutes which prohibit the taking away of any unmarried girl under a certain age, consent on her part is no defense. Even when the taking is at her own suggestion, it is no defense. Thus where a girl solicits her seducer to elope with her, and he does so, her solicitation is no defense. Section 212, Improper Motive essential. To constitute the crime of abduction, the act must be done with an improper motive. Thus, where the proof shows that the accused honestly believed that he was entitled to the custody of the girl, although in fact not legally justified, he should be acquitted of the charge of abduction. Section 213. For the purpose of prostitution. Where a person is prosecuted under a statute which prohibits the taking away of a girl for the purpose of prostitution, it is not sufficient to show that the wrongdoer's purpose was to have sexual intercourse with her himself. Thus, an indictment under a statute which makes it a crime to entice away an unmarried female for the purpose of prostitution is not sustained by proof that the accused, by false representations, procured her to go with him to a neighboring town, where, having induced partial intoxication, he had repeated sexual intercourse with her. A penal statute is to be construed strictly, and the word prostitution does not mean seduction, or sexual intercourse confined exclusively to one man, but a common indiscriminate illicit intercourse, or offering of the body for an indiscriminate commerce, with men. At least, she must be enticed away for the purpose of sexual intercourse by others than the party who thus enticed her, and that a mere enticing away of a female for a personal sexual intercourse will not subject the offender to the penalties of the statute. A prostitute, as defined by Webster, is a female given to indiscriminate lewdness, a strumpet. And prostitution, as defined by him, is the act, or practice, of offering the body to an indiscriminate intercourse with men. Common lewdness of a female. Section 214. For the purpose of concubinage. When the indictment is under a statute which makes it a crime to take away a female for the purpose of concubinage, or prostitution, this particular purpose must be shown. As to the meaning of the terms concubinage and prostitution, courts differ. Some give them a more liberal interpretation than others, and apply them to all cases of lewd intercourse. The statute which names as illegal purposes of such enticement of females under the age of consent, includes marriage, concubinage, and prostitution. The last two were evidently intended to cover all cases of lewd intercourse. Neither of these words has any common law meaning, but both are popular phrases, either of which might be made to cover the crime here shown without any change from general usage. As a general rule, however, the enticing of a female from her parents' house solely for the purpose of having sexual intercourse with her by the party so enticing, is not a crime under the statute. Thus, where a young woman living with her parents is enticed by a man to leave home and meet him for a few hours, and have illicit intercourse with him, within a few rods of her home, after which she returns to her parents' house, as usual, the case is clearly not within the scope of the statute, as it lacks the necessary ingredient of the offense, an intention to induce the female to a condition of either common prostitution or concubinage. Evidence of the enticing of a young woman to leave her parents' house and come to the defendant's, where he finally succeeded in overcoming her virtue, after which he had illicit intercourse with her 2 or 3 times a week, for about 9 months, and solicited her to live with him, promising her money and clothes, and that he would treat her as well as his wife, is sufficient to convict the defendant under account for enticing the young woman away from her home for the purpose of concubinage. Section 215. Sexual intercourse not essential. Abduction committable by a woman. To constitute the crime of abduction, sexual intercourse is not essential. It is enough that the woman was taken for that purpose. Moreover, sexual intercourse is not essential to the crime of enticing away a female for the purpose of concubinage or prostitution. Nor is it essential to such crime that the wrongdoer succeed in reducing her to that condition. The gravamen of the offense is the purpose or intent with which the female is taken away from her parent or guardian, or person having legal charge of her person. Section 216. Chastity of the female. Under the statutes of some states, the unchastity of the female, at and prior to the time of her alleged abduction, is immaterial, except in so far as it may affect her credibility as a witness. On the other hand, under the statutes of other states, including Illinois, chastity of the female is an essential element of this crime. It is to be observed, however, that the law presumes chastity, and notwithstanding the general presumption of innocence, in a prosecution for abduction the burden of proof, in its secondary sense of going forward with evidence, is upon the defendant, and he must overcome the presumption of chastity. Moreover, an instruction that the presumption of chastity of an abducted female is only a bare presumption, and does not continue after the production of any competent evidence to the contrary, is properly refused, since it ignores the probative force of such presumption. Section 217. Circumstances attending the taking. The gist of the crime of abducting an unmarried female residing with her parents is the taking or enticing her away from her parents' house. The purpose of the taking or enticing must exist in the mind of the wrongdoer at the time of the act. On the other hand, the fact that such purpose is unknown to the girl is immaterial. The taking or enticing may be to a place distant or near, or for a long or a short space of time. Moreover, it is not essential that the girl should be kept permanently away from the parental home, or that there should be any intention so to keep her, even where the charge is for the purpose of concubinage or prostitution. Section 218, Federal White Slave Traffic Act. There is a federal statute which forbids the transportation from one state to another of any woman or girl for the purpose of prostitution or the debauchery or for other immoral purpose, on with the intent and purpose to induce, entice or compel such woman or girl to become a prostitute or to give herself up to debauchery, or to engage in any other immoral practice. This statute includes transportation for practically every form of sexual immorality, including mere fornication,